Good afternoon. My name is Crystal Dahl, and I'm the Online Communications Specialist here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar. You want more time off? Dealing with employees' medical leave requests under the FMLA and ADAAA. I have the pleasure of introducing today's speakers from Meritas' Atlanta, Georgia affiliate, Parker, Hudson, Rayner, and Dobbs, Trish Treadwell and Tiffany Johnson. In addition to employment law, Trish spends a significant amount of her time practicing franchise law on the franchisor side. When not practicing law, she is practicing her tennis game with her husband Derek. They have a 10-year wedding anniversary coming up next week. Congratulations, Trish.
Thanks.
You're welcome. In Tiffany's short career, she has already won more pro bono cases through her Atlanta Volunteer Lawyers Foundation work than many litigators do in a lifetime. This is, of course, in addition to her undefeated trial record for the firm's paying clients. She recently adopted her first pet, Emmett, who will be featured in one of the scenarios today. Finally, Trish is a fitness buff and enjoys working out with her personal trainer at least 6 times a week. Before we get started, I would like to quickly go over a few housekeeping items. As many of you have likely already noticed, all telephone lines have been muted. If you have a question, you are welcome to ask via the chat feature found on the left-hand side of your screen. If you experience any technical difficulties, please press *0 at any time to connect with a support technician. With that, Trish, are you ready to get started?
We are ready. Thanks, Crystal.
You're welcome.
Okay, well, I'm glad that everyone has been able to join us today, and we probably will have a few people coming in a little bit later. We all come to these types of webinars and learning experiences with different backgrounds in employment law, so I don't want to presume too much knowledge because I'm sure there are some of you who had not even decided you wanted to go to law school one day when the ADAA's amendments were passed in 2008. And for those of us who've been practicing a little longer, Tiffany and I will try to keep some of the basics that we're going to go over as brief as possible. But I do think that they must be stated in order to place the Family and Medical Leave Act and the Americans with Disabilities Act in context and to determine how they overlap and interact with each other on the subject of employee medical leave. I want to encourage you all, as Crystal mentioned, to please submit questions as we go online. Tiffany and I will try to answer as many of them as we can, either during the webinar as they are relevant or at the end. It's also probably the best way to make sure that you all get the most out of the webinar.
And everyone, this is Tiffany. I just want to reiterate that while we're all here for a variety of different reasons, we always support Meritas webinars.
That, of course, is one of the primary reasons why we're here. But most importantly, one of the things I want to talk about one of the reasons I want to talk about this topic is because I get more questions from clients and potential clients trying to understand FMLA leave more than almost any other area in employment law, except maybe classification of exempt and non-exempt employees, and that would require probably 2 more webinars. And while clients have understood the basic obligations to provide FMLA leave and to accommodate employees with disabilities, they often struggle, especially of late, to strike a balance between fairness to the employee and practical considerations for their companies when it comes to allowing employee leave. I think some of the questions are, how much is too much leave? How much is not enough? How much is just being stingy? What's going to actually get me in trouble? Where's that line? And what's fair when you're comparing yourself to other employers? We're going to begin with what I think of as the simpler of the 2 statutes, the Family and Medical Leave Act. You may hear me refer to it as FMLA or FMLA for short. Just again to go over some basics about this statute, it was passed in 1993 after the Americans with Disabilities Act was already in effect. I think that's important to note because FMLA was clearly intended to cover something different than what the ADAAA already covered. The primary concept being that if an employee is sick and cannot work, but likely to recover soon, the law should protect her job. Same for parents after the birth or adoption of a child. Same for employees who have primary caretaking responsibilities or immediate family who become sick. There's an additional category for military service members and their families, but I'm going to leave that section out for the purposes of this webinar. Basically, you get a little more time under a few additional circumstances. Congress tried to balance this idea of an employer having to give an employee leave by trying to consider what that burden would be like on smaller companies. As a result, this statute only will apply to employers with over 50 employees within 75 miles of each other. An employee qualifies for FMLA leave only after he's been working for at least 12 months for the employer and in the last 12 months has worked at least 1,250 hours, which comes out to about 25 hours a week over a year. Of course, an employer is free to expand upon that and offer additional leave or grant leave to employees who have not been there that long, but that's something that would be entirely up to an individual employer or up to an individual state if they chose to expand a state law that expanded the FMLA leave. An employee qualifies for FMLA leave if he has a serious health condition. That's an illness, injury, impairment, or physical or mental condition that involves inpatient care or continuing treatment by a health care provider. Or, as I mentioned earlier, if an employee has an immediate family member who has a serious health condition and requires care or the birth or adoption of a child. In any rolling 12-month period, a covered employee may take up to 12 weeks of leave under the FMLA, and rolling 12-month period is usually calculated as, for example, if an employee requests leave starting on May 1st, you look back over the last year to the prior May 1st to see how much of the 12 weeks of leave the employee has left. And you do that instead of just looking at a calendar year. An employee is not required to take all the leave at once. They can take it intermittently, so down to the smallest increments of time that the employer uses for any other kind of leave, as long as it's at least by the hour. So an employer can't require you, if you need to miss some portion of the day, they can't require that you just take the whole day. They would have to say, well, if I normally measure leave by the hour, then you can take it by the hour or by even down to the 15-minute increments if an employer goes down to that small increment of time. Employers may also require certification or documentation from a health care provider of that serious health condition, when it began, how long the condition or the treatment for the condition will take, and some explanation of the employee's inability to perform the essential functions of his or her job. And if the FMLA leave is for a family member, an employer can still request that information and an explanation of what care the employee is required to provide for that person. For example, if I have a family member who's an immediate family member but sick across the country, but I have a sibling who can take care of that person, just because I have an immediate family member who's ill does not mean that I necessarily have the leave. It's only if I'm required to be the caretaker for that person. If an employee does not provide that requested certification, his leave may not be protected. And that's a critical issue, and one we'll pick back up on later as we look at where the FMLA and ADAAA intersect. Last point on the FMLA is that, stunningly, sometimes employees may say they're sick or say they need leave, but the employers don't believe them. An employer is permitted at its own cost to require an employee to get a second opinion from a health care provider of the employer's choice and at the employer's cost, but they are allowed to do that. And if that doesn't work, they're allowed to get a third medical opinion from a health care provider that both the employer and the employee agree on, and again, that is also at the employer's cost. If the employer requests that certification, again, and it's not provided, that absence is not protected, And the employer may terminate the person, and we'll talk about what other considerations an employer may have to make before that termination, but a termination is possible just based on an employee not submitting that certification. Employers could also require a fitness for duty certification from a healthcare provider in order to show an employee's ability to return to work capable of performing the essential functions of the job.
So this is Tiffany. The other act we're going to discuss today is the Americans with Disabilities Act and the 2008 Amendments Act. The ADAAA was, as Trish mentioned, was passed in 1990 prior to the FMLA as a comprehensive civil rights legislation which prohibits discrimination on the basis of a person's disability. At the time, in the 90s, disabilities under the ADAAA were considered on a very traditional, we had a very traditional understanding of what disabilities were. So think being confined to a wheelchair or having a severe mental impairment. But then in 2008, Congress passed the sometimes difficult to remember all the A's, the ADAAA, or the Amendments Act for short, in response to decisions by the Supreme Court that were continuing to narrow the concept of a disability sometimes inappropriately. So the 2008 Amendments Act expanded the definition of a disability, which we'll talk about a little bit more. The ADAAA covers all employers with at least 15 employees, so it covers more employers than FMLA. And it requires an employer to provide some buzzwords here, a reasonable accommodation to qualified employees with a disability. So all of those are loaded terms. First, a qualified employee is an employee who can perform their job with or without an accommodation. So if the employee can't, for some reason, meet the essential functions of the job, then that employee is not a qualified employee. The definition of a disability, as I just mentioned, has transformed over time to be incredibly more inclusive than was originally stated. The 2008 Act actually explicitly removed a time limit that was in the original Act of 6 months. The idea was that the original definition of a disability was something that was more permanent, whereas by 2008 that definition had expanded to less permanent impairments. So a disability is something that substantially limits one or more major life activities. Again, the 2008 Act expanded both of those ideas. Substantially has been essentially read out of the statute, so virtually any limitation on one or more major life activities is going to qualify as a disability. And you see the examples of major life activities: walking, breathing, seeing, thinking, and that's going to cover pretty much anything you could possibly think of. So if an employee is qualified with an ADAAA disability, the employer is required to provide the employee a reasonable accommodation. And oftentimes, and for purposes of our presentation, leave or time off of work is almost always going to be a reasonable accommodation. At least some form or some amount of leave is going to be a reasonable accommodation. And that concept has evolved over time because originally the reasonable accommodation had to allow you to perform the functions of your job, and it's a little bit counterintuitive to accommodate someone by allowing them to not perform their job for a period of time. Under the idea of a reasonable accommodation, an employer is not required to provide everything the employee asks for, but the employer is required under the ADAAA and under many state statutes to engage in an interactive process with the employee, which can mean anything from sending an email to the employee and asking if there are any accommodations they might need, or sitting down with the employee over a period of time and trying to determine what's best for both parties. If in that interactive process the employer cannot find an accommodation that will fit the employee's needs, or the accommodation is just simply too expensive or too difficult to implement, the employer is not required to provide that accommodation because of the idea of an undue hardship. And what's important to remember is that it's increasingly difficult with the expansion of the ADAAA to prove undue hardship. And really the only one that has been recognized on a consistent basis by the EEOC is that indefinite leave requests, which are basically, I don't know when I'm going to return to work, but I need to be out. Those kind of requests are almost always going to be unreasonable, and the employer is not required to give an employee indefinite leave. Otherwise, you really got to document everything and make sure that your reasons for not providing an accommodation are well documented. And employers should be careful that even when they feel they're being generous, they are going through the process of determining whether an accommodation is reasonable, including automatic termination provisions of employee contracts, which we'll get to a little bit later.
Okay, well, looking at these two statutes, there's some very clear kind of practical implications that come out of this. And the number one rule is that when you get a medical leave request from an employee, ensure that you're counseling your clients, or that it's directly a client, that what you're doing is processing those leave requests through both the FMLA and the ADAAA unless you have reason to believe otherwise directly from your employee. The EEOC is on the lookout for lapses by employers when they're not doing this, when they may be following the FMLA, but then they're not incorporating any restrictions on their actions based on the ADAAA. And they're looking for examples that can go up on the EEOC's website, examples that can be posted in employers' offices as consent decrees or notices. And so you don't want to be that employee, you don't want that employer, you don't want your clients to be that person. So it's important to make sure that your clients are going through that complete analysis. What we thought we'd do in order to kind of go through some of these as examples is talk about a few examples that Tiffany and I have had, and I'd say probably within the last 6 months, just a few examples of client inquiries that we've received kind of on the looking over the timeline of a potential leave request, starting from requesting the leave, an employer requesting information about the leave, more information, all the way to the return to work. And so we're going to go through a few of these scenarios for you today. And again, I definitely encourage you, if we're not answering a question you might have that sounds related or you'd like answered, please type that in and submit that to us. We're happy to try and answer those questions again as we go, or try and get to them all at the end. So I'm going to start out because I have a question, Tiffany, that I hope you can answer.
All right.
I have a client who's requested leave, a client who has an employee who's requested leave. This is a small medical practice, Little Docs. Little Docs LLC. Little calls, they're asking for some urgent advice. they have a surgical assistant, an employee named Emily. We'll call her Emily. Emily reported that she has an unspecified back injury from a car accident. She can't stand for more than 10 minutes. As a surgical assistant, she's pretty much required to stand for at least 10 minutes at a time, probably far more than that normally. And she has now been on FMLA leave for a little over 11 weeks. Her FMLA leave is set to expire on October 6th. But we just found out she's got back surgery scheduled for October 10th. So the question is, first, did Little Docs even have to give Emily FMLA leave?
Okay, so the first question I have for you, Trish, is you said it was a small medical practice. How small?
It is. It's a small office, but we're in a major metropolitan city, and they've got a few small offices spread around the city. So each office has about 25 employees. They've got 4 offices, all in the same city.
Okay, so unless this is a ridiculously large, sprawl city, you're probably going to be covered under FMLA because you've got at least 50 employees within a 75-mile radius.
Okay, and we thought we were, so that's why we went ahead and gave her the leave.
Okay. So the question about Emily in particular is, how long has she been working for you?
She's been employed at Little Docs for about 5 years. She was a part-time employee working about 20 hours a week for 3 years. And in the last 2 years, she was promoted to a surgical assistant, and she's been working full-time ever since.
Okay, so you probably definitely made the right decision to go ahead and give her FMLA leave, because Emily is absolutely covered under FMLA because in the last year, she's been a full-time employee and has worked the 1,250 hours required to be qualified.
Okay, well, their primary question, thank you for answering that. Their primary question is, now that they know she's got to go and have back surgery, can we just fire her today? I mean, her leave was going to run out on the 6th. Today's the 1st. Can we just fire her today?
Absolutely not. And the reason for that is FMLA, the purpose of FMLA is to secure the employee's job for that 12-week period. So during those 12 weeks, you can't fire Emily until her FMLA is up. You can't assume that she will exhaust it and still need to be out. Since you don't know what's going to happen, you definitely shouldn't fire her before it expires.
What if we were going to fire her anyway? I mean, before she got in this car accident, we had her separation notice drafted. I actually have a copy. It was all written up. We were going to offer her severance. We had the whole thing ready to go. She'd been written up 3 times in the last year. So if they were just about to fire her anyway before she got injured, can't we still fire her on the 6th?
Well, this question comes up a lot in motions for summary judgment for employers who have already been sued. The risk you run by firing an employee during their FMLA leave is that it looks like either retaliation or interference. And you run the risk of having that happen and having to explain to the court your legitimate, non-discriminatory reason for firing Emily. So save yourself the time and money and wait until her leave is up.
Okay, so let's say we do wait. We wait until October 7th. So her leave ends October 6th. Can Little Docs fire Emily on October 7th?
Well, Little Docs probably shouldn't fire Emily on the 7th because Little Docs doesn't appear to have done any kind of ADAAA analysis. If Emily's condition regarding her back or her whiplash from the car accident ends up being an ADAAA disability, and Little Docs hasn't gone through any determination of whether reasonable accommodation is required, they can be in violation of the ADA. And more than likely, given the expanded definition of a disability, Little Docs is going to want to at least engage in that interactive process with her and determine whether a few more weeks of leave might resolve the issue.
Okay, I hear what you're saying, and I just want to clarify. You're saying that even though Little Docs has already given Emily 12 weeks off of work, that the ADA might still require Little Docs to give Emily even more time than the 12 weeks off of work.
Absolutely. And it's unfortunate because it seems like a trap, but the ADA and the FMLA are separate federal requirements. It just so happens that now they seem to cover the same things. So an employer needs to evaluate whether the ADA is covering that employee that's out on FMLA leave before making an adverse employment decision.
Okay. We'll make sure to relay this information, but I don't know if they're going to like it.
All right. So our second scenario is really going to look at how an employer goes about requesting information from an employee. So I have this client, NYC Styles, and they're a clothing company, and they've got some retail associate named Emmett. Emmett's been complaining about his wrists hurting, and now he says that he's been diagnosed with a severe form of carpal tunnel, such that he can't use his hands at all, and he needs surgery. So our HR director required certification from Emmett's doctor, and Emmett just can't seem to get it together. He keeps losing the form, he won't return our calls, and we haven't gotten the paperwork back, and it's been almost 2 weeks. My client doesn't believe that there's a real thing, such a serious case of carpal tunnel where you can't use your hands at all, and they think that Emmett's trying to cheat them. Can they fire Emmett?
That's a tough one. The employer in me wants to fire Emmett immediately. But because it's hard for me to imagine someone having such severe carpal tunnel that they cannot even work. But I think the wisest move is probably to take a step back and figure out what's going on. First, how long did NYC give Emmett to return his FMLA certification paperwork?
I think probably right at 2 weeks.
Okay. Well, if they gave him 2 weeks, the FMLA is going to require that he get at least 15 days to return the certification. So NYC doesn't want to take any action until they've at least let those first 15 days expire. So I would definitely make sure they do that. And then they may just need to gather to kind of get that initial information. It may be that even after those 15 days expire, they might want to consider, checking back in with him and offering another week or so before, because most employers are going to be a little bit more flexible about that 15-day deadline before you pull the trigger and fire someone, unless there's a very, very severe hardship that would occur if you didn't fire that person immediately.
Okay, so we're not quite at 15 days, but they did have one other question. They didn't use the Department of Labor form to they didn't send the Department of Labor form to Emmett. They just sent him an email with some questions that he needs to send to his doctor. Are they going to get in trouble for that?
Now, the Department of Labor created a form, and For those of you listening, it's one of the resources that are attached. The Form WH-380, it's not a required form, but it's easy to download off the internet, it's easy to use, and it requests the exact information that employers are allowed to request without asking for too much, and while still limiting the request to the information related to this particular serious medical condition. They're going to, as long as the employer is only asking about healthcare provider contact information, start and end date for a serious medical condition, and medical facts about the condition, and finally information about whether the employee can perform the essential functions of the job. As long as that's what's being put out there, then it's absolutely fine.
Okay. So we don't really have to wait more than 15 days, technically, right?
You technically don't have to wait more than 15 days, but I would highly recommend that an employer at the 15th day send something out in writing. Listen, dear Emmett, dear employee, I'm giving you 7 more days, or I'm giving you 2 more weeks. If you don't have this to me, your FMLA, you do not have FMLA coverage. Your absences are not excused. And so that just needs to be very clear to the employee.
Okay. So let's say on the 15th day, Emmett's doctor sends us the information that we requested. And the doctor's explanation of Emmett's serious carpal tunnel is just, it's not clear. It doesn't make a whole lot of sense for why he needs to suspend his wrists. And the employer's just not buying it. What are NYC's options at this point?
I'd say there's 3 options. 1, just let Emmett have the leave and move on from there. Sometimes employers get tied up in the fact that they feel like an employee's getting over on them, and they end up spending more time and energy fighting that than it's worth. And you might not want to be, the employer that's letting people run over you, but sometimes it might be a situation where you just let it go. Second, the employer can ask for clarification. If the healthcare certification, the healthcare provider certification isn't sufficiently clear, if it just says Emmett has carpal tunnel syndrome and cannot work, maybe you need to follow back up and say, I'm sorry, here are the things that Emmett's required to do. He works in a store. He folds sweaters for a living. Can he not do that with carpal tunnel syndrome? Or, so get that clarification from the medical provider. Not another certification, but clarification about it. And finally, and this is not, I'd say this is the most severe option, would be to just require a second opinion. The FMLA allows an employer to go back and say, no, Emmett, I want you to go to this doctor who I'm identifying, because maybe you just don't trust Emmett's doctor. And it's at the employer's cost, but you could ask Emmett to do that.
Do you run any risk requiring all these second opinions and clarifications?
Almost everything we do is risk, because you start doing that and questioning every little bit of illness. You start saying, well, I don't believe you, and asking a few too many questions, and that can be construed as FMLA interference, which means that you are somehow chilling this person's ability to take their legally allowed medical leave. And so if you're interfering with their ability to take that leave, and by asking all of these questions, or by demanding that they keep giving you more and more medical information, that is definitely a violation of the FMLA. The other issue is, at some point, Emmett might come back to work after this leave, and if you were so hung up on the fact that Emmett was lying the whole time, he comes back and suddenly he starts experiencing what he believes are adverse employment actions solely because you're mad that he took off that much time. And that can also expose an employer to a claim for FMLA retaliation. So a discharge or some kind of discrimination against an employee just for having exercised his or her FMLA rights. And that can get an employer in a lot of trouble as well.
All right. I'll let my client know.
Absolutely do. All right. So, moving on to a new one, returning to work. As I mentioned at the end of the last one, if you have Emmett coming back to work, we have somebody who's returning to work. But I'm a little worried about this person's return to work. I have a client, construction client, Constructco. After a back surgery, their construction foreman, Ernie, was cleared to return to work as the construction foreman, but had to go to physical therapy 2 times a week and took Vicodin at least once a day, but also as needed for pain. And Constructco doesn't want Ernie climbing construction beams and operating heavy machinery if he's taking Vicodin. Plus, it's just difficult to have a construction foreman who's not on site because he has to run off and go to physical therapy twice a week. Constructco feels like its only option is to refuse to let him return until he can come back full-time and without Vicodin. Is that a problem?
Okay, well, my first question for you is, when you say Ernie was cleared to return to work, what do you mean? Do you mean your client requested a fit for duty certification?
Well, he called and he said, I'm ready to come back to work, and my doctor has cleared me.
Okay, so to answer your question regarding whether Constructco can, I guess, fire Ernie without liability, I think there's a pretty clear no there, because you don't know at this point whether Ernie can perform the essential functions of his job or if he has an ADA-covered disability. So you want to make sure that you're not violating the ADA. But since Ernie's been out on FMLA leave, you can require Ernie to provide a fit for duty certification from the doctor who treated him. And specifically in this instance where you've got physical therapy that's required and he's taking a narcotic for his pain, you want to include a list or a description of Ernie's essential job functions, and specifically request information about whether Ernie can perform those essential job functions while taking Vicodin. That seems like that's a particularly important issue to your client.
Yes. My understanding is it'd be difficult for anyone to be operating heavy machinery while on a painkiller like Vicodin. So we'll have to, you said we can go back and get clarification for that, though.
Well, you should definitely at least pursue the fit for duty certification from the healthcare provider.
Okay. Would the ADA come into play at all here?
Absolutely. Again, it's not clear whether Ernie's injury or surgery, whatever caused him to need surgery, is an ADA disability at this point. It's probably limiting Ernie in a few different ways. Your back's connected to all the important parts of your body, so you might not be able to lift things. You might not be able to walk around as much or stand up all day. You mentioned earlier that ConstructCo they felt like they were pigeonholed a little bit because they wanted to know that Ernie was healed and ready to come back to work. And you definitely want to be careful under the ADA not to require an employee to be 100% healed. And that is it's been absolutely determined by the EEOC. The ADA does not allow an employer to require an employee to be 100% healed. The only thing an employer can require is that Ernie be able to perform the essential functions of his job. If Ernie's injury is an ADA disability, then ConstructCo needs to go through the reasonable accommodation analysis and determine, whether the physical therapy appointments are a reasonable accommodation. And since it's probably only a few hours a week, most likely that's going to be a reasonable accommodation.
Okay. What about the issue of whether it's even safe for both Ernie and his coworkers to have Ernie there on Vicodin and at a work site?
Right. Most likely, the most likely outcome is once you get that fit for duty certification from the doctor's going to make it clear that Ernie shouldn't be operating heavy machinery. And I think that's the most likely outcome. But if for some reason the doctor doesn't come to that conclusion, your client has the ability to get clarification from the healthcare provider, or under the ADA, ask the employee to submit to an entirely separate medical exam. And all of this is going to factor into whether allowing Ernie to operate heavy machinery under the influence of Vicodin is a reasonable accommodation. It sounds to me like your client is pretty concerned about it, and it might not be, especially given the safety issue.
We have a question that's kind of on this same topic. What is the best way to deal with an office employee whose productivity has declined and whose performance appears to be impaired, possibly due to prescription painkillers? And I'm going to go ahead and answer that one just because we were just talking about Ernie here with the Vicodin. I think question one on that would be, my follow-ups would be, one, is this actually a prescription painkiller and the person is using them as appropriate, or is this an illegal drug use and the person is a drug addict? There is no ADA disability for people who are drug addicts and using drugs. If this person has been a follow-up that it's being used as appropriate, then I think what you want to do is get some type of medical certification to say what having a job description that identifies the person's essential functions and determining whether or not, having a medical determination about whether or not the person can complete all of his or her essential functions of their job, even if it's just kind of a regular office job, considering they're taking this pain medication. If it's a matter of productivity declining only, where the essential functions are still being kept, but instead of being an A-level employee, this person is now a C-level employee, but safety is not a concern, the safety or health of others is not a concern, it's just the person is just not as productive as she used to be, then I think there probably needs to be, if a doctor says the person's fine, then you probably need to have a discussion with that employee about, is there anything, and I think the best way to approach it is there anything we can do to help you? We've noticed that your performance or your productivity has declined. And I think that's the best way to approach it, because you don't want to assume that there's some type of disability. So you want to give the person an opportunity to say, yes, as a matter of fact, I'm experiencing severe migraines and I've been taking like crazy amounts of Percocet every day just to get through the day, and it's very difficult. It would be great if I could do A, B, or C. And that would open the door to have a discussion or a negotiation about that. That would probably be my best suggestion for them to try first and foremost. I don't think you want to approach the person and say, hey, you look like you're high on painkillers every day. You have to stop that. You want to definitely approach it in as understated a way, but to determine whether or not there is an ADA-covered disability there. Okay.
So we've got one last scenario here that is important and timely given the most recent EEOC guidance released about pregnancy discrimination. I think it just came out in July. And Trish, I've got a client, Prego Sauces, and they've got an employee who is a warehouse supervisor, and she's pregnant, and about 4 months into the pregnancy, she let Prego know that she intended to use her FMLA leave after the baby was born. So Prego's been using, or they've been conducting themselves accordingly. Then 2 months later, about 6 months in, Elle began suffering from pregnancy-related issues, complications like sciatica and depression. So she went to her doctor and got a note from the doctor that suggested that she reduce her work week, go on a reduced hour schedule, and he also said that she shouldn't be lifting heavy objects, which is important to her job as warehouse supervisor. So Prego wants to know, they like Elle and all, but if she can't do her job, why can't they fire her?
That is a commonly phrased way to ask that question. She can't do her job, or he can't do his job. Why can't I fire her? Well, the first thing is, let's see, if Elle can't do her job, why can't Prego fire her? Well, number one, because it's likely an ADA violation. You mentioned before the new EEOC guidance. Whereas a pregnancy itself has always been a very specific exclusion to the list of disabilities, what has now been kind of encroaching on that is this idea of pregnancy complications. So any type of pre-birth complication, post-birth complication, those are all considered disabilities under the ADA. And as disabilities, there are going to be certain requirements, likely for leave and other reasonable accommodations, that an employer will have to do. And particularly with respect to pregnancy issues, it is very difficult to say that it's an undue hardship because we know exactly what the term will be. It is never indefinite, because we know that at some point that pregnancy is going to come to an end, although I have had a client say that they thought it was an indefinite leave request when someone went out on a pregnancy complication issue, and they did try to argue, not with my sanctioning, but they did try to argue that it was an indefinite leave request, despite the fact that presumably the pregnancy was going to end in 2 more months. So that's the biggest issue, is that firing her beforehand, if her accommodations she's asking for per her doctor are 1 or 2 hours less a day and not lifting heavy things, if she's a warehouse supervisor, she can probably find one of the other employees who can do that, lift some of those heavy things for her, and I'm sure there's a reasonable way the employer could have her work a couple hours less a day.
Okay, so they can't fire her, but there's this increased risk with, or they believe there's an increased risk with Elle being being ill and also being very pregnant, can they move her to a light duty office to avoid any potential liability? I mean, she seems more likely to get hurt.
Yeah, that's the whole she's a frail little girl princess theory, and that type of paternalistic approach is exactly the reason for the Pregnancy Discrimination Act, because employers were saying, oh, well, she's pregnant, she's with child, she can't possibly be in this office environment, or she can't possibly choose to be in a situation. These cases came up in the sense of women who are working in factories where they might be exposed to chemicals that could cause problems, including sterility if you were in the time of your life where you could get pregnant, or if you were pregnant, it could cause issues. That is not an employer's decision to make. So if L requests light duty work or office duty work as a reasonable accommodation because she's having some pregnancy-related complications, that's very different than if Prego just feels like, hey, we're concerned about you because you are with child and we want to protect you. And that is an ADA violation.
Okay, so the other issue is that since she has these ADA-covered disabilities, she's also been using her FMLA time during this period that she's on a reduced hour schedule. And it's looking more and more like she's not going to have very much time left after her pregnancy to spend time with her child. Does she get more FMLA time?
Yeah, that is a real tough one. And it's a tough one, I think, for employers because it kind of puts them in a difficult position where they've already given someone an extended amount of time and they've used up that FMLA time. And once you've used that time up, it is gone, and FMLA does not extend that time. The things I would suggest that the employer look at and that any employee consider is whether there are state law protections that may expand those 12 weeks and grant 26 weeks or some other amount of time greater than the FMLA leave time. Also, if you're looking at whether or not, if she had a either kind of, it could be pre-pregnancy or then pregnancy-related complications that were all considered disabilities, it's possible that there might be some post-birth disabilities. She may have some continuing issues if she had an early C-section or something along those lines, and so that she had some continuing problems after the birth of the child, then that, whatever leave she needs in order to recover medically, then that may be considered a post-pregnancy disability, and she might be able to request a reasonable accommodation, and an employer should consider that if that's an issue. If, as you explained it, and there is no post-birth disability, she was ill going into it, but she has the baby, she's perfectly fine, she just wants to stay at home with the child for a little while, or if the child has some issues. In either of those situations, the ADA doesn't cover the child. The ADA only covers that employee, and so unless, as I mentioned, there's additional state law protections, or if the employer just has a process where normally the employer gives additional time beyond the FMLA leave, then that's what you might want to look at. And this kind of, I'm going to tie in a couple of questions that people had just because they're connected to this issue. I mean, if you are within that rolling 12-month period, then you get your 12 weeks. If for whatever reason, after that 12-month period, so you went from May 1 and then you had on May 1 through August 1, I think that's roughly 12 weeks. If you had that period of time off, then looking back to May 1 the year before that, your 12 weeks are up. If anything happens within the remaining 9 months, you've already used up your 12-month leave. But once that kind of time rolls around, and let's say by now it's June 1, and the person needs 2 weeks of FMLA leave, yes, because looking back, you still have 2 more weeks.
Right, and the process of certification and requesting information, all that starts all over again.
Yes, if the person is asking for additional leave, yes, you absolutely need to do that process all over again. I also recommend that employers, if somebody needs, for example, if there's someone with cancer and they need an initial FMLA leave in order to have a tumor removed and some initial treatment for 2 months, but then they need to have intermittent leave for chemotherapy treatments, I always request that people have your clients do those separately as 2 separate requests so that it's less confusing, I think, for the records. One last thing on this scenario, I think it's important to note that if it's the employer's habit to give additional leave, you need to make sure that you're doing it in a fair way. You cannot give 3 warehouse workers who all had testicular cancer, 20, yeah, I know, you guys want to check your water. You don't want to give all of them 26 weeks of leave in order to recover just because you're being nice, and then you have a woman who would like to spend that additional time with her child at home and you say no to her, because you're setting yourself up for a potential gender discrimination claim under Title VII, and now you've got a terrible superstorm of ADAAA, FMLA, and Title VII, and it just gets very messy. So you want to be careful of that. That was our last scenario. I'm going to go back and somebody asked if you have a large number of employees who've requested intermittent leave but just kind of using it as a placeholder, can you rescind the approval after a period of time? If they're not using it, it's not so much that you rescind the approval, but you are allowed to ask for a recertification. And you can do that without being considered someone who's interfering with the FMLA leave if you do it on, let's say, a month-to-month basis or something like that, just so that you're just checking in with them again, saying, just go ahead and send me again your paperwork about how long you think this is going to last, what's going on, what's the update. You're allowed to get that additional information. If the employee starts acting as though they feel like you're interfering or they don't want to give any more information, then you want to be cautious and maybe talk with counsel at that point. I would suggest that your client talk with counsel at that point. But otherwise, an employer is allowed to follow up. And so if that person can't go back to a doctor and get a note explaining why they need additional intermittent leave, then no, it's cut off, it's over. So that's the best way to handle that issue. And I'm checking to make sure that we've answered all of the current questions. If anybody has any further questions while we're trying to wrap up, I'm going to talk about just some last few things about if you remember nothing else today from this 1 hour, I hope that you guys remember these things. First, treat all medical leave requests as covered by both the ADAAA and the FMLA until there are facts that suggest otherwise. Facts from the employee, I should say, not facts that you just surmised. Some leave is almost always a reasonable accommodation under the ADAAA. And as Tiffany mentioned, it is very difficult for an employer these days to establish that it is under an undue burden for a small amount of leave. It is almost impossible. Number 3, be proactive about determining whether the ADAAA applies after the FMLA medical leave time has been exhausted, after those 12 weeks have been exhausted. Be proactive, ask those questions, contact the employee. Don't just sit back and wait, which is what a lot of employers want to do. They don't want to rock the boat. They're like, well, I'm just going to wait till they ask first. Number 4, the EEOC believes that all automatic leave policies are per se violations of the ADA, so be very careful and do not have those, even if you think your policy is extremely generous. A 52-week leave policy can still be considered a violation of the ADA.
And if you guys look at the slides following this presentation, there's a case in there, Morse versus JetBlue Airways, out of the Eastern District of New York. It's a pretty recent case where an inflexible 52-week maximum leave policy, which sounds pretty outrageous, the employer was actually denied summary judgment on that point. So it's definitely up in the air. It is real.
All right, and lastly, be aware of the hidden potential for violating Title VII or other statutes that prohibit discrimination or disparate impact, like we mentioned with the granting of additional medical leave to some people but not to others. It doesn't mean that somebody's going to actually be guilty of that. It doesn't mean that they're going to be able to prove that, but it does mean that it will give an employee a foothold into a lawsuit, and you want to be careful about that. Really quickly, I know we are just about out of time. I'm going to try and answer these last couple of questions. First, I'm pretty sure that Crystal is going to make sure that everyone has copies of the slides as well as copies of some of the resource materials that are identified in some of the last few slides that follow, including a list of cases that support all of our various scenarios and some EEOC documents. Next, does the additional ADA leave time granted after the FMLA expires count as FMLA leave for the purpose of figuring the 12 months? After the FMLA expires, it's not FMLA leave anymore, except to the extent you're counting it as like the next kind of rolling 12 months. You can still count it against those rolling 12 months. So it's still medical leave under the FMLA. Any leave that qualifies can always be calculated as part of FMLA leave. So if you grant somebody an extra 3 weeks because it's a reasonable accommodation for a disability, then yes, when you do that 12-month rolling 12-month look back, yes, you count those extra weeks that you gave them. When giving an employee requesting FMLA the paperwork, should you also go ahead and give them ADA paperwork? I think when you give them that paperwork, I think in connection with that paperwork, if it's not on those documents, I think what you should do is ask if there's any kind of reasonable accommodation that the employee might need. I think you want to ask something along those lines at that time. And I've seen that worked into some types of FMLA forms. And maybe if you're sending it in an email or something like that, you could ask that question in the email while you're still attaching the DOL FMLA form that requests it.
And again, if it's not with the FMLA certification form, it probably needs to come up at some point before FMLA is expired. And that's just part of being proactive about it.
Okay. I think that's all the questions that I've seen. If anybody else wants to get in touch, once you get the slides, our contact information is on the slides, so feel free to contact either me or Tiffany. And thank you all so much.
Thank you, Trish and Tiffany. What a great job. I loved the scenario format that you used to demonstrate your topic. Very nice. Before we sign off, I just wanted to let each of you know that in the next few days, as Trish mentioned, that we will distribute a copy of this presentation, a recording of the webinar, as well as their contact details and additional resources that they've offered. So I'll send that out as soon as I can. Please do not hesitate to reach out to either of them directly if you have any further questions. With that, thank you again for taking the time to join us, and have a great day. Bye.
Bye.